I'm going to
Good evening.
8:15.
This is the January 15th, 2009 edition of our seminar series, Austin Constitution Meetup. Thank you for being here this evening. The announced agenda for this meetup is the legislative program. And after getting into it further, I pretty well concluded that this is going to need more than one meeting to do justice to it, or even to try to give you an overview. So I'm going to give you the first part of an overview. This will be number one. We're not sure yet how many it's going to go into, but probably go into several. But I'd like to get into enough detail so that you can get a handle on some of the things you're going to need to do to play your part in pursuing this legislative agenda. Now, I've decided not to put the PowerPoint on the wall tonight. I'll put it online instead. It doesn't add that much to the presentation. It doesn't appear that well on the video, and but it will be available for you if you want to use it for your own talks. And in that connection, I want to encourage you to think about doing this kind of talking yourself. It's not supposed to just be a series of lectures by Jon Roland. My ultimate hope is to train all you guys to succeed me. Get out there and deliver the message to the world. You know, I'm not going to be around forever, and especially some of you younger guys need to learn how to do this kind of thing yourselves. And in that connection, I want you to think about practicing this, doing your own talking on some subject of your choice. We can tape it, or rather record it, as we're doing with my talks. You may or may not want me to put it up online, but we can put it up temporarily, just at a hidden location, so you can view it yourself and critique yourself. Because very few things are more effective at training you how to be a good public speaker than being able to see yourself speaking. And that way you learn to improve your technique. We may have the internet, but public speaking is still a critical tool in achieving necessary political reform. And because for starting, of course, with one-on-one encounters with individuals and expanding into these videos that I'm producing, it will hopefully be viewed by a lot of people. And by the way, don't forget, when I do post these things online, to tell your friends about them, to try to spread the word to various lists and forums and so forth, to try to encourage a wider viewership. Because I'm going to try to cover the subject fairly thoroughly, and this provides a useful tool in addition to my writings and other writings of others and the other things that people are doing, to build a body of thought and discussion that can eventually achieve the results we desire. Now, what I thought I'd do is to bounce back and forth between federal and state. There's also a local dimension to this. There are local rules, for example, rules of court, city council rules, whatever, which could bear on this at some point. But at this point, we're primarily focused on the U.S. Congress and the state legislature. And the reason why it makes some sense to bounce back and forth, although it might cause some confusion, is that there are similarities between the two levels of government. And what I'm going to focus on in this evening's lecture are judicial reforms, because many of the other reforms depend on them and cannot be effectively made without making judicial reforms. Now, some of you know I recently attended the National Convention of the Federalist Society, which is a association of conservative and libertarian lawyers mainly, but we have some other kinds of scholars, historians, economists, and so forth. And it gives me an opportunity every year when I attend to get a sense of where the legal fraternity, at least one segment of it, the generally more politically active segment, is going. And it's interesting. It's been interesting to watch it develop over the years. But one can also come to perceive, sometimes subtly, the problems that we have in order to achieve the reforms we seek. That was probably most clearly shown by this talk by Justice Antonin Scalia, which I recorded and which is linked to the website, constitution.org, in which a question was asked of him: by what criteria do you decide to overturn precedent in order to, well, the implied meaning, although not so stated, was to conform to the Constitution? Because it's an ongoing issue, especially in that circle of lawyers, how much precedent should play in the ways federal courts make decisions. There's a widespread understanding of the problem that when precedents start deviating from the Constitution as originally understood, and judges make decisions based on precedent rather than on the Constitution, that eventually you have the line of precedents drifting away from the Constitution and never getting back to it. I discuss this in a paper on my website, on stare decisis, in which I characterize it as in fundamental conflict with constitutional law. Because what you have are two different logical systems. The Constitution can be viewed as a system of logical propositions which are supposed to be logically consistent with one another. They don't necessarily cover all issues, but none of them are supposed to be in conflict with one another, or with the legal practices of government officials subject to its rule. And of course, we do indeed have practices, policies and practices, as it's called in the field, that are in conflict with the Constitution as originally understood. And unless we can find some way to bring their decision-making back to constitutional compliance, we're going to have an increasing strain between the two bodies of logic, as it were, which I like to explain by reference back to George Orwell's 1984. Winston Smith insisting that 2 + 2 make 4, and O'Brien say, "No, Winston, you're not sane. We're trying to get you sane here. Don't you see that 2 + 2 make 5? And finally, Winston, under threat of having his face chewed off by rats, said, "Oh no, all right. 2 + 2 make 5." Said, "No, Winston, you still don't have it. Sometimes 2 makes 5. Sometimes it makes 3. Sometimes it's something else. It's whatever the party says it means from one moment to the next." But the point is that the logic of power and the logic of law are two entirely different systems. And precedent is the logic of power. And if we allow judges to rely only on precedent, then we have a fundamental problem, and one that is going to lead eventually to, I think, civil conflict. Now, where does all this lead to us? Well, in his talk, Justice Scalia said that he would consider overturning precedents in a few extreme cases, but he wasn't going to go back and review all the bad decisions made by the Supreme Court. And he seems to think there are a lot of them. So he's not disagreeing with us that there are wrong decisions that have been made by the Supreme Court or that the courts are following them. But he's saying that I'm not going to do that because, quote, I'm not a nut. Now, what he's saying there is that not just that I don't want to be thought a nut, but one would have to be a nut to try to review all these past decisions and overturn all these precedents. So right off the bat, he's admitting that no, I'm not here to comply with my oath to uphold the Constitution. I'm here to keep myself out of trouble with all these guys that are going to criticize me if I step out of line, if I, become not in the middle of the herd, but on the edge of it, or maybe outside the herd. He talked about catching heat, catching hell from critics. Well, which critics? I don't think he wasn't talking about the general public or the kind of people who populate our various forums that criticize judicial decision making. He's mainly talking about his peers, his power peers, at the higher levels of government, society, academia, and so forth. So people at that level do not really care what the public thinks. Yeah, we might cast a vote, but if we're not going to vote on these issues, then it doesn't matter. And for the most part, people don't. And what we've seen also from the courts, I sent out a email message in which I essentially, a selected list of footnotes for a court case, in which the court essentially said that these are all the reasons why we're not going to challenge the constitutionality of this, that, or the other. And if you read between the lines, what they're really saying is that, look, we don't want to take the heat for deciding these constitutional issues. If we take a case, we'll decide it we'll seize on some grounds for deciding it that's as narrow as possible, and we'll never decide a constitutional issue if we can decide it on some non-constitutional issue. So we're going to leave all these constitutional issues unresolved. The reason why we're going to do that, they didn't say it there, but some judges have said it on other occasions. We want you, the public, to fight it out in the political branches. We want you to get your legislators, your congressmen, your president, people like that, to make the reforms you seek. If you do that, we'll support you if and when you do that. We're not necessarily wedded to some ideology here, but we're not prepared to buck these other two branches. I mean, the executive branch has the guns, and the legislative branch has the money. Now, what do we have? We don't have money. We don't have guns. Push comes to shove. If the IRS is going to tell you we're going to audit you if you don't decide these cases the way we want you to, well, some of us might resist that, but a lot of our colleagues are not. So we need the support of the people in order to do what you want us to do. And we're not getting it. And unless and until we're getting it, we're not going to help you. So that lays the burden on us, which is why I'm speaking here tonight about legislative agenda, both state, U.S. and state. Okay, well, it's easy to say, all right, so we need to get on our congressmen, we need to get on our state legislators to adopt this or that or another piece of legislation. But what? Well, attempts have been made to legislate. Congress has tried to legislate judicial rules of procedure, only to have the courts say, no, we're not going to do that. And if we try to make us do that, we'll just declare it unconstitutional. This is our bailiwick, we're going to do things our way. And of course at that point you say, well look, if Congress can't legislate rules of procedure, then what is it that you're expecting us to do to take the heat off of you so that you're not deciding these cases the wrong way from our viewpoint? Well, as it turns out, there are legislative reforms that speak to rules of legislative procedure that could be made, but one has to take a somewhat indirect approach to it, and I'm going to be getting into that. So we're going to look at several categories here of reform. First, the appointment of judges, assignment of judges to cases, grand juries, trial juries, qualification of lawyers, judicial rules, which I just discussed briefly, and forms of pleading. And what is it going to take to try to depoliticize? And by the way, you may have noticed on the hearings today for Eric Holder, members of the Senate mispronouncing the word politicize, a politicization rather than politicization. But just a little English, grammar police there. Okay. During the Federalist Society Convention, all these judges were ranting and railing about judicial independence, had a whole session devoted to judicial independence. But then the subject came up about this jail proposal, use grand juries to remove judicial immunity, official immunity from judges, so that they can be sued or prosecuted or whatever. And they were all against it. And they cite as the reason for it that it would destroy their judicial independence. Now, of course, from the viewpoint of the reformers, we say, now wait a minute, we don't mind if you're independent of the executive branch or the legislative branch. What we don't want is for you to be independent of the Constitution. But of course, all they see is prosecutors, members of the executive branch, using grand juries against people. And as far as they're concerned, any reform of that kind would be used by the executive branch to control them. And they might be right. This is a criticism I've made of the jail proposal on numerous occasions, that you don't want to make a proposal like that unless you can make sure that it can't be captured by the very people that you're trying to use it against. And grand juries have been largely captured by prosecutors. And it's very instructive to understand how that came about. We'll be getting into what we might be able to do about that. But one of the problems with the politicization of judges it simply arises from the fact, most people don't really think about it in these terms, appointing judges to particular positions on a particular court, starting with the Supreme Court. When we appoint a judge, is to a place on the Supreme Court. Well, why? There's nothing in the Constitution that says that we can't just appoint federal judges and assign them at random to any of the courts from one day to the next, even the Supreme Court. There has to be a Supreme Court, but there doesn't have to be a fixed composition of it. You could have an entire pool of federal judges, and on any given day, from one day to the next, 9 of them are picked at random and they serve on the Supreme Court. We almost do that now at the lower levels, but there's a lot of reassignment of judges from court to court to court. When this country was founded, a lot of the judges rode circuit. That's where the word circuit comes from. They just kept traveling around from court to court to court. The cost of paying judges is not so great that we could not appoint 10 or 100 times as many judges as we've got. And that means, of course, that any given judge would only handle a few cases. It would only be a part-time job for him. Yeah, we could pay him. But most of the time, we could have them do other kinds of work. We could have them research, write, teach, perform clerkly duties, or represent indigent defendants pro bono. That might help bring them to earth, as it were, and help them understand the problems that ordinary people feel out in the real world. If they were required to research, write, and teach, they learned their subject matter better. And a lot of judges really don't know the law that well. And if they were charged with filling in all the holes in judicial writing that they could find anywhere in the literature, you know, okay, you guys go out and look, find all the subjects for law review articles that nobody's ever written about before. Fill in the gaps. Research the history of this or that or the other. So it would make them better judges, and of course it would depoliticize the courts to a large degree, because you wouldn't be able to control who was going to decide cases. You could have a general influence over who goes into the pool, but the result would be largely determined by a random draw. Now, of course, that also means I would recommend that all judicial panels be composed of at least 3 judges. So you never really have the case hanging on one judge who might be a doofus. However, it would be argued, well, if you're randomly moving judges around, what about their clerks and the magistrates and all these supporting people? They would elevate their power if they were left in place. You would wind up, the judge shows up, to court one day and says, okay, this is my first case in this court, and I'm new here, and can you guys show me around? Sure, Judge. Here we have all these cases, here's yours, and here's the way you need to decide it. Okay, well, you have the obvious problem with that. It's a similar problem with the Congress, with proposals for term limits. If you limit the terms of congressmen, it means the staffers become too powerful, because they're there for 20, 30 years or more. They develop relationships with other staffers, with members of the executive branch, with lobbyists, with various other people, and they become a power unto themselves with an agenda of their own. A new congressman is usually confronted with having to hire staffers who aren't really working for him. They're working for their tribe. And that's a problem. So we would have to do the same kind of random reassignment of staffers, of clerks, of other people like that as well as of judges. And of course, in today's world of easy transportation, easy communication, there's no reason why we couldn't do this. It wouldn't necessarily cost that much. The main cost of the courts is going to be much the same, and it doesn't matter if we have, 10 or 100 times as many judges, that much. But I think the results would be salutary because they could teach future generations of lawyers, they could do the research, writing, do the clerking. Somebody has to do the clerking, might as well be a judge. Or representing indigent defendants. Well, we now employ legal aid societies or legal aid departments, depending on who pays for them. And they might just as well be someone who's better qualified. So I would say that on the whole, this would represent a real reform that would go a long way towards solving a lot of the problems we have. Now, for the Supreme Court, I had a convention of the Federalist Society in 2005 that I attended. The keynote speaker was our Senator, Jon Roland. And as is my habit, when there's microphones at which people can ask questions, I am almost invariably one of the first to the microphone. Make it a point to sit near the microphone and trip anybody who tries to get there before I do. So I had this question of Senator Cornyn. Senator Cornyn, the United States Supreme Court can only take about 80 of the 8,000 cases that are submitted to it each year. That would seem to be a bottleneck. What do you think about the proposal to increase the size of the Supreme Court to 27? I said then, I would say 28 today. Like the Ninth Circuit, have cases initially decided by randomly selected panels of 3, with appeal to randomly selected panels of 9, and from there appeal to en banc panels of 27. And of course my revised proposal is with one extra one serving as an administrator. That would change the whole dynamics of the Supreme Court. For one thing, any precedential value of a decision by the first 3 wouldn't be that strong, because it would always be subject to being reviewed by another randomly selected panel of 9 or by all 27. And by the time, if it ever got to the 27 en banc, there would be a considerable amount of weight and discussion and debate and so forth to support that. So, of course, the audience was initially sort of shocked, and then they broke into laughter and applause. Of course, this was a time when a Republican was in office, and in fact, we'd be court packing. Except, of course, when combined with my other proposals, we wouldn't exactly be court packing if we also increased the number of judges generally, and if they weren't necessarily assigned to the Supreme Court. Now, another one of my reform ideas, which I'll mention here and I'll mention again later, is to require a unanimous vote of a multi-judge panel to sustain a power of government against a claim by an individual challenging that power. There's nothing in the Constitution or the law that says that a multi-judge panel has to decide by majority vote. 5 to 4, well, that's one way to do it, but that's just their practice, their policy and practice. And that should be contrasted with the rule for juries that requires them to be unanimous to sustain a criminal charge against an individual. Now, why should a panel of judges decide by majority vote when a jury has to decide unanimously? Well, I don't think they should. I think if a single judge thinks that the individual has an arguable claim that the government doesn't have some authority, then it ought to be decided in favor of that individual. Even if it's 26-1. Because if he can convince one judge out of all those other judges that the government doesn't have the power, that, in my view, is sufficient doubt that the government has the power. And in cases of doubt, the decision should always be made against the official. Anyway, that's something to contemplate there. Now let's get on to grand jury reforms. First of all, the members should be selected at random. A lot of people think they are. They're not, at least not at the state level. Our own local judge here, Judge Baird, wants to do that, to select grand jurors the way that trial jurors are selected. In other words, from the voter list. There might be some screening done. Obviously, they have to serve for a long period of time, so you're going to try to get people who are willing to do it. But right now, the way it's done is it's the cronies of the judges, and sometimes of the prosecutors. And the results are predictable. The grand jury all too often becomes just a rubber stamp for the prosecutors. And believe it or not, as a matter of law, the prosecutor is not supposed to impede access to the grand jury by ordinary citizens. Judge Baird recently intervened on the behalf of one citizen, so he could take a complaint to the grand jury, which is how the whole thing got started. But it shouldn't have to depend on a judge intervening that way. And, well, the prosecutor's office said, somebody in it said, well, you know, if we let people have direct access to the grand jury, they'd just be all these frivolous cases. Well, that's what grand juries are for. They're to screen out the frivolous charges. You know, if too many people are filing frivolous complaints, that may be something the grand jury itself wants to investigate. Maybe there's a problem with official policies and practices that are not perhaps accurately represented by the complaints, but there may be some kind of pathological situation that requires further investigation. It may also be an education problem. Maybe people aren't being educated properly as to what their rights and responsibilities are. If that's the case, then that itself becomes the proper subject for the grand jury to issue a report on. They might say, well, you know, public schools, you need to be teaching people what the law is on this or that or the other, and what it's not, and what your duties are and what they're not, and what the duties of officials are and what they're not, and when they're out of line. And of course, the public schools are going to say, whoa, we don't know how to do that. And of course, the grand jury can say, okay, we'll come in and teach your students. So there are lots of possibilities. Now, how would you actually remove the impediments to citizens accessing the grand jury? Well, of course, first of all, you require that the contact information for the grand jury be published publicly, so anybody knows how to contact them. And the contact should be made directly. The grand jury could perhaps hire a staffer or somebody to handle the mail or whatever form it comes in, but it should not be the prosecutor being the gatekeeper. Because the prosecutor's office, the DA, is not a neutral party. They are a party of interest. So they should not be playing a gatekeeper role. It can be made a crime or a cause of action to impede access of the grand jury. And And this is where we get bounced back between the federal and state, because right now there is a federal crime making it for a state official to deny a right to a citizen, a person. But it's a little bit vague. And the courts have tended to interpret that narrowly. And the way to deal with a problem of this kind is simply to be more specific. To say, among the ways that an official can deny the right to someone under this clause is by denying access to the grand jury. 10 years, $10,000 fine. Well, that would kind of take care of it pretty quickly. Or to create a cause of action. Okay, now, the first one would come under 18 U.S.C. 242. That's in the criminal code. The second would come under 42 U.S.C. 1981 to 85, which deals with civil cases, civil jurisdiction. And the way that one can open the courts to civil action on these issues is to be specific about what it is that, if done by an official, somebody could sue them for it. And of course, one of the things that could be specified is, impeding access to the grand jury. So, if these things are properly worded, they can open the system to intervention by citizens, and thereby enabling us to begin to move the ball in the direction of constitutional compliance generally. Now, one of the things that grand juries are not now asked to explicitly decide, although they do actually decide it implicitly, is whether their court has jurisdiction over the case. Now, you say, well, most grand jurors don't know how to decide jurisdiction. Leave that to the judge. Well, the judge isn't necessarily always going to decide properly. This is particularly a problem, one of my beefs, is where, you said, well, let me step back a second. It is part of current procedure that a state case can be removed to federal court by just filing it in federal court and saying, removal to federal court. And then the federal court has it until it decides whether to keep it. It can remand it back to state court, or it can dismiss it, but it does take time and money, and you have to answer the argument of the person removing it to federal court why the federal court does not properly have jurisdiction over it. And the problem arises with that is the federal judge deciding whether or not the federal court has jurisdiction over a state case, or at least a case that started in the state. Now, there are certainly many, many cases that are properly removed to federal court. But one that is regularly removed to federal court and that I have a problem with is when a criminal offense is made by a federal agent. He's charged under state law, murder or whatever. It's removed to federal court and then dismissed because he was on duty. Therefore, he has official immunity. Well, the problem is that being on duty is not the criteria for whether or not an official has jurisdiction. What it's supposed to be is he carrying out the law? It's the law, not getting a paycheck, that gives you immunity. If you really are enforcing the law, then it makes some sense to confer official immunity. If But if all you're doing is being on the job and you violate the law, then that should not, then your immunity should cease. But judges still haven't been following that concept. And by the ancient principle announced by me, juries were invented because judges can't be trusted. So the obvious solution is to have a jury, grand jury in this case, decide on a case of removal. In other words, if there's a conflict of jurisdictions between two different courts, a grand jury should be convened to decide which, if any, court has jurisdiction. So take it out of the hands of a judge who is a party in interest, and let a randomly selected panel of people decide. I think we get better decisions that way. Okay. The bill of indictment should be considered not just as authorization for the DA, the official public prosecutor, to proceed to conduct a prosecution. It should be an appointment of the complainant, whoever it is, to be the prosecutor. Now, if he wants to let the public prosecutor do it, fine. If he wants to do it himself, that's okay too. Now, if he's going to do it himself, maybe he wants to get the assistance of the public prosecutor, or maybe he wants to get the assistance of others. But in any case, he should be in the driver's seat, because there's a fundamental problem with people taking cases of official misconduct to grand juries only to realize that only the public prosecutor is allowed to prosecute them. And of course the complaint may be against the prosecutor himself, or his buddies in his office, or members of law enforcement agencies that he works with every day, or of course the judge, even the judge who supervises the grand jury. Okay? We do not want these people to be above the law. And because they have been above the law, they have been misbehaving. That's what happens when people aren't adequately supervised. If you don't supervise your servants, they become your masters. So we need to change the system so that ordinary citizens can intervene at many points in order to achieve that needed reform. And on a slightly different subject, this is not part of my program, but I'll mention it here. The subject has come up in recent weeks. What do you do about something like the meltdown? A lot of people are attacking libertarians as, this is a failure of the market, failure of capitalism. No, it's not. But the market economics, only really applies to the interactions among organizations or individuals. It does not describe the behavior within organizations or individuals. All right? It would be a real stretch to apply market economics to describe the operations, the internal operations of your body. All right? Every one of your cells is not negotiating contracts from one day to the next to prices. There's no pricing mechanism involved in the way the cells of your body decide how and whether to do things. So there are many phenomena in this world that are not governed by the principles of market economics. And in the economic field, these are mainly big organizations. And Milton Friedman once said in a TV interview, which I wish I had a copy of, I'm in favor of free markets, but I'm not of large organizations. He was in effect saying that. All right, what is the problem with large organizations? Alan Greenspan said that he was shocked and surprised and alarmed that large organizations, that's not the word he used, but that's what he meant, were not being disciplined by the market. And of course the answer is that when you have large organizations making decisions according to their own internal dynamics, they are not necessarily constrained by the marketplace, especially when they get too large, too well connected, or too many play the same strategy. When that happens, they're beginning to emerge as a single large organization. Maybe not legally or formally, but they are acquiring the characteristics of a monopoly. So you have is monopolistic behavior. And part of the problem with the internal dynamics of large organizations, which are typically organized in a hierarchical fashion, is that conflicts of interest develop typically between middle management, upper management, and the lower staff people. And the particular problem is in the middle management area, because these guys are on the way up. They hope to rise within the organization, and they will often engage in practices that advance their careers, but that are inimical to the best interests of the ultimate owners of the organization. And we can see that dramatically in the meltdown situation. The owners were in effect taking the view, well, as long as the profits are coming in, we don't care what middle management is doing. Well, tell that to the investors of Barney Madoff. He showed them apparent profits, so they didn't question his business practices. In effect, he was a kind of middle manager between the investors and the investments. And with the results we see, as one poor investor put it, well, I was prepared for risk, but I wasn't prepared for fraud. Well, there's a fine line between risk and fraud, particularly when the incentive structure is such that the people involved win either way, even if their investors lose. And you cannot count on people to always do their job the way they say they're doing it. You have to supervise them in some detail. So how does that relate to grand juries? Well, like a lot of libertarians, I'm suspicious of government intervention. A bureaucrat going around and applying some statute or regulation, to the operations of a company generally accomplishes very little except to raise the cost of that company. The company might even welcome it because it can suppress competition from smaller competitors. Most of the regulations that we've got on the books now arose from that reason. They started about 1886 with the Interstate Commerce Act, which was mainly directed at the railroads, and it very successfully enabled the railroads, the big ones accepted it, even supported it, because it enabled them to stomp out the little railroads and the coach lines and the trucks, people like that. There weren't any trucks then, but later on that became the little competitors. So, what then is the alternative? Is there nothing that can or should be done to deal with the problem that I've been discussing? Yeah, because when organizations become too large, too well connected, or play the same strategy, they cross the line into becoming matters of public concern. All right, you might be you might own a factory and you're polluting a stream or putting pollutants in the air. He says, well, it's my land, my factory, I should be allowed to do what I want to here. We say, wait a minute, there are externalities here. You're imposing external costs on your neighbors. He says, okay, let them sue me. Well, the problem is that no one of them is being injured enough to make it worthwhile for him to hire a lawyer. Now, they could all get together and hire a lawyer, class action suit, but that's, of course, very expensive. You may recall the movie with Jon Roland, Civil Action, where a bunch of citizens tried to do that. It was based on a real case. And eventually they won, but the lawyer went broke. Now, I recommend the movie because it provides a classic exposition of a problem that citizens have in dealing with certain kinds of threats. And what I propose as a solution is to use grand juries to investigate these situations. Not to apply any particular set of rules or regulations or statutes, but just to poke around and see if these large organizations are doing anything that is a threat to the public or to their shareholders. And if they find something, to present it, to issue what's called a presentment. A grand jury report is called a presentment. Now, they wouldn't necessarily have to reveal any trade secrets or anything that would be inimical to the proper interest of the organization. But if they discover, for example, that middle management is, well, a favorite issue of mine is refusing to hire anyone with more than 10 years of experience because they want compliant workers who aren't going to challenge middle management's policies and practices. And as the grand jury can say, well, wait a minute. You're refusing to hire all the people who can, if they were in your organization, bring out the fact that you guys are about to drive your company into the ground. Is all right. We're sending this report on to the shareholders, board of directors, and we'll let them decide what to do about it. Well, if enough of this were done, in my view, I think it would make a big difference for the better. It could certainly have avoided this whole meltdown that we are seeing. There were plenty of people who were aware of the problem, but almost all of them were commenting from the outside. Nobody was on the inside, checking to see what was actually going on. You have to have a way of getting people in who are not part of the problem. And if you had enough grand juries poking around in enough organizations, I think you might have some salutary effects. Maybe not. I'm sure there are some downsides to all this. It would certainly require a lot of tweaking. But I'm of the view that, I'm not here to lay out a complete detailed proposal that would deal with every problem. I'm just here to get it started. But I think it would be extremely useful if enough people were to write their congressman saying, look, Congressman, we want you to empower grand juries to investigate these organizations, their internal workings. They do it on an ongoing basis and disclose any problems that they might encounter. If enough people did that, we might avoid the problem of a depression in which people may actually be starving to death in the cold. So, and of course finally what a grand jury needs to do, it would do, which I discussed earlier, was to decide whether an official has acted within his jurisdiction, any official. The grand jury wouldn't be the one deciding what to stop the official or to remove him from office. That, I propose, should be done by a trial jury, separate operation. But they can clear the way toward conducting a trial. Now let's go on into trial juries. Yeah, Jim?
Okay, on you wanting the grand juries to be able to go into organizations, I'm pretty sure we're talking about public organizations or public entities, because a private business has a right to be immune from anybody looking at their business, as long as they're
Probable cause.
Yeah,
No,
but
that's an external stimulus.
Actually, they don't. The
well,
grand
if they
jury-
went public for stock orders, I would see that. But you know, what about the privacy,
well,
the right to run your business the way you want?
Well, see, that's why this is an innovation.
Okay.
Because when they become large enough, powerful enough, when their failure can bring down an entire economy and collapse governments and do all sorts of other nasty
Yeah.
things,
No, I agree with
then
that.
they are no longer just a private enterprise. They are engaged in practices that are too dangerous to be left unsupervised. Yeah, Alan.
Isn't it true that it's virtually impossible for a business to reach that size without incorporating and thus having protections from the state and thus therefore duties to open its books?
That's
Yeah.
right.
Yeah, now there,
So
that
the
makes
private
sense.
business would be
Right.
small anyway.
The legal principles are already in place to make it allowable. But in principle, a grand jury can investigate anything now. You know,
Probable cause.
yeah. Well, it doesn't even have to have probable cause. They can investigate anything.
Well, you don't want that.
But something has to form the grand jury. There's some stimulus that will do that, and then they have to be directed at a particular question, if I understand.
Well, what
needs to be
they would
brought.
have to be responding to a complaint.
Right.
Okay, so you would still depend on maybe having whistleblowers or something like that, but it could be a very generalized complaint. It could be a complaint, you know, there are too many companies that are too large, too well connected, and they're all playing the same business strategy, and I think they're headed toward disaster. You know. Ellen?
And a private individual gaining knowledge through experience and interaction or secondhand from overt conversations doesn't fit the definition of a whistleblower if he doesn't work in the company.
Mhm.
But if he sees a pattern that evinces a basis of a complaint, he should be able to bring it.
Yeah, exactly. Yeah, it's a potentially tricky area, and I don't deny that that could be tricky, but the alternatives are worse. Whether over-regulation on the one side, I think of Sarbanes-Oxley as my model of how not to do it.
Well, I'm looking at Freddie and Fannie. I mean, the oversight was totally absent there.
Yes,
And
there was nobody going in there poking around to try to find the problems.
well, even looking at the poor business practice, but Congress approved that.
Yeah, because Congress is not equipped to supervise these entities at the level of detail that it would require. Now, they could do things like appointing special prosecutors, special masters, administrators, so forth, to go in and poke around. Several, you know, the SEC does that, for example, but they do it, they're always guided by a particular set of statutes and rules, which are usually written for the disaster, 2 disasters back. So you have to have a free-form investigative body that is not bound by a particular set of rules, but can be looking for all the ways that clever middle managers can evade the last set of rules and are headed for disaster. Now, this would require, now the main problem with my idea here is that it would require a fairly sophisticated grand jurors. And there is a problem of where you're going to find people like that. And I know I could put together 1, 2, maybe 3 grand juries of 23 each of people like that. But after that, I would be hard pressed to populate them with qualified people, because you have to know a lot about accounting and business practices and business modeling and finance and a lot of other things in order to do this sort of thing effectively.
Well, I was thinking about that too, and I'm thinking, isn't that the original intent behind the management part of the Office of Management and Budget? They were supposed to be overseers of the agencies, not just to supervise that they spent their budgets as promised and required, but also to see that they were following good business practices and being honest. And again, cronyism enters in because it's a federal position, you're part of the civil service, so maybe part of your innovation could be to pull that piece of the OMB out of the patronage system and create that cadre of professionals who have an immunity similar to that of federal judges, so that they can't be punished for looking in, they can't be stopped, and so on.
Well, what I would tend to do in favor would be using a lot of retired people, retired experts, whose pensions are secure. You know, maybe they can be killed, but they've led a good life anyway. That probably not. If they're guys like most of the old geezers that I know, they don't give a shit.
Make sure their kids are around.
I would love to go into the military supply system.
Yeah.
I could save them millions.
Well, I saved the Air Force. I saved the Army between $2 and $4 million in about 10 minutes one day. So.
Wow.
So I don't mind taking VA benefits because I think I paid for them.
All right.
But yeah, you got a question?
Well, is the premise too large to fail wrong?
I think it's wrong.
Well, the problem, it is in a way, because some organizations, if they fail, will cause so much misery that
Can you pepper some examples of misery?
well, let's say even your own local bank, if it fails and it's not protected by FDIC, you lose all your money. And therefore, and not only you lose your money, but your employer goes broke, and he has to lay off all his workers, and the next bank, because he owes them too, they go broke, and it becomes a domino effect. Too big to fail usually means triggering a domino effect. If an organization can fail by itself without triggering a bunch of other failures, then that's one thing. But if they're going to start the dominoes falling until they're all laying flat, then you've got a problem. And this is where too well connected comes in. There are a lot of people who say, well, we should not have let Lehman fail. They're too well connected. There are a lot of failures that have resulted from not bailing out Lehman. And in fact, a lot of them are now being bailed out with even more money than might have otherwise been necessary. So, of course, I think the bailouts probably won't work. The problem is too large, and we're doing it too late. It might have made some sense 10 years ago when this problem first got started, but if you let it go too long, you get to a point where the dominoes are already falling, and you can't stop enough dominoes from.
Right, but it seems that the larger problem is that the government has set up institutions that have aligned things in this domino kind of pattern, so that any one piece of it triggers the whole thing.
Yeah.
And then you have the Federal Reserve rushing in to be lender of last resort, to devalue my assets, the only one I'm allowed to have,
You see, there have been speculative bubbles even before there were governments. The problem can occur even without the participation of the government. Now, without a doubt, the government helped make it worse. But even if it hadn't, we could still have, and probably would still have a problem. So it doesn't really work to say, well, take government out of the picture completely, because we still get back to the problem I discussed earlier, that the market only applies between organizations, not within them. Now, what the answer that would have been made to that point in the end of the 19th century would be, well, just break up all large organizations into little ones. You know, maybe no corporation can have more than 100 employees, say, or something like that. Well, in today's economy, that's probably not really practical. There are a lot of departments that are bigger than that. Yeah, I've worked for some large organizations where, in principle, you could have, every department could be a separate company. And of course, they had so many contractors running around that you kind of thought that that's kind of what you had sometimes. But there are problems with having a swarm of small organizations all contracting with one another from one day to the next. And the reality is, and as I've seen in such situations, is that they might be separate legal organizations, but because of the way they're all functioning together in a swarm, they're really functioning as one large organization anyway. Yeah.
Yeah, there's a name for that in Japan, Kyatsu. But I'm wondering if a bailout shouldn't be accompanied by mandatory receivership. Target got into trouble 10 years ago, and over the course of about 5 years closed about 17% of the stores. Now they're one of the strongest companies in the country.
Mm-hmm.
So yeah, starting earlier is better, because now it might be too late, but force these companies in if they want the money, they have to accept the oversight, and they have to be willing to have all their weak limbs cut off. Because when you spin off, a failing unit quite often becomes successful, because the major corporations sucking the blood out of it. They're going for economies of scale, and each one of these has to be a profit center, but it doesn't have an HR unit, and it doesn't have these other support units. You take that, when you spin it off, you have to install that, the profit stops flowing up, and then the thing finds its true market value. And then there's another question, too, of whether 90% of products sold in this country are sold just because somebody figured out how to market them, and they have no validity anyway.
Mm-hmm. Yeah, well, market value is based upon what people are willing to exchange for it, not necessarily what it's really worth to them if they were making rational decisions.
Absolutely, but
one of the
to bail out an irrational
one of the innovations in economics, which is I recommend people look into further, is what's sometimes called behavioral economics. Behavioral economics doesn't view economic behavior as a marketplace, as a monetary system. They look upon economic decisions as essentially psychological decisions. And it's relevant for our discussion because what we're really talking about here are not really rational decisions, they're emotional decisions. And when you get enough people, large herd of people making emotional decisions instead of rational decisions, then you do not have classical economic behavior. But you have the behavior that is actually occurring and does occur. And herds and their psychology are a subject that needs to be studied on its own terms. If we're going to understand our situation, we have to study the market actors as they really behave and not as they should behave if they were rational. The market tends to impose rationality on the actors in the long, midterm, the long term, even if the actors are playing short-term strategies. But there can be an awful lot of distress along the way. Libertarians are fond of talking about the invisible hand from Adam Smith, or spontaneous order. However, what they're really talking about from the physicist's point of view, what they're really talking about is a tendency toward equilibrium. Most of these systems we're discussing are in disequilibrium. They're tending toward equilibrium. They may be homeostatic in the sense that the equilibrium is dynamic. But there's nothing in this picture, in the theory, that guarantees that at the end of the day you have anybody left alive. Remember, there are economic behavior in the evolution of species too, and most of them are dead. So, I mean, ecology is essentially a larger field within which economics is a subfield. But, you know, there's nothing in ecology or economics that guarantees the survival of any player or even all the players. A desert is equilibrium, you know, devoid of all human or even vegetable life. So we do need to take a broader theoretical approach to these subjects than just the one that we get within the libertarian framework. And I'm a scientist by training. I try to deal with reality and to just understand it on its own terms. And sometimes that means we have to put aside our ideological preferences. In fact, it always does. It's all right to have an ideology of looking for the truth and going where it leads us, but you have to be prepared to accept whatever you find there. But enough of this little diversion. Let me get back to, we want to get out of here eventually. Trial jury reforms. First of all, what I have long recommended is that there be no disclosure of panelist identities to the parties during voir dire. There's no reason why the lawyers in deciding which jurors to strike should be able to see them, to know their names, to look them up on the internet, and to generally maybe even conduct a, you know, fairly effective, you can do a fairly quick background investigation of people today if all you know is their name. So what I would recommend in the present situation is that the panelists, prospective jurors, be able to see the lawyers not be able to see the panelists or know anything about them except their numbers. Be able to send them questions and the jurors send them back in writing, but so nobody can tell their age, gender, race, professional background, or anything. Because right now there's a jury stacking is becoming a major area of subversion of the judicial process. And with the way the trends are moving in that on that subject, we're soon going to get to the point where juries are being selected by the litigants rather than the verdict selected by the jurors. The questions should be limited to matters of capacity or bias. You know, do you know? You can see the lawyers. Do you know any of these guys? Have any of them ever represented you or anybody you know? Have you, are you related to any of the litigants and so forth? Then, it's my view that jurors are judicial officers. And the U.S. Constitution says that all judicial officers at all levels of government in the United States must take an oath or affirmation to uphold the Constitution. They are not now being asked to do that. What they are being asked to take an oath to do is to follow the laws given to them by the judge. Now, I don't have a problem with that exactly, because if the judge tells me something is the law and it's not, I'm not going to follow it. But of course, I'm going to know what the law is, and that what he's telling me isn't it. You know, I'll follow the law if he happens to be right. If he's right, then it's the law. If he's wrong, then it's not the law. But most people are not prepared to do that. And if you really want justice in this country, you want decision by juries composed of people like me. I'm not going to be biased either for or against either side, but I'm going to be really, really careful to get it right. And that's what you want. And none of this business of deciding with juries of less than 12. There's a reason for 12. Historically, we've tried other numbers, and in the time of Henry II and Edward I, 12 was a magic number, so there was a little bit of a bias toward that number. But as it turns out, there are excellent social dynamic reasons why 12 is a good number, and a larger or smaller number is not. And all these juries in the state level, where a decision is made by a jury of 6, or made by majority vote instead of unanimous vote, are unconstitutional and should be so held. Finally, the supervision of the process of choosing the jury should be done by the grand jury. You can't trust judges or sheriffs or people like that to supervise the process. They're liable to say, oh, well, I did a random selection, and, well, we just happened to get nothing but former cops. And it's just pure random, you know. Well, no. If there's a random process, I want somebody supervising the selection process who is not part of the problem. And that means some kind of jury. And the natural choice is some kind of grand jury. Yeah.
Is it illegal then or unconstitutional that when you get in the jury room, the lawyers question the potential jurors and throw them out? Or I guess they're allowed to throw out 3 or something, but they
have a certain number of strikes.
Yeah, strikes. Okay, is that constitutional or?
That is constitutional, but it's being abused because it's possible to get too much information about people now that we used to not be able to get. And in my opinion, they're also able to ask them too many of the wrong kinds of questions that shouldn't be asking them.
Yeah.
You know, like, have you ever heard of the Fully Informed Jury Association? Or have you ever heard of jury nullification? Yeah, I saw an episode of Law and Order in which they discussed it, but I didn't really understand it. Yeah, right.
Is that the answer? Or anyway, you're struck, right?
Yeah. Well, what they're tending to do now is to strike anybody who's educated.
Yes, it all is.
And I don't think that we should be striking educated people from juries.
We should strike dummies.
As a defendant, how are you ensured that you are being tried by a jury of peers if you can't see the jury?
Well, that's where the supervision by the grand jury would come in. The grand jury should be the one, they should be able to see who the jurors are and make sure that there really is a jury behind that screen, you know, that they're composed of 12 randomly selected people. Otherwise, you could just, you know, say, well, there's really a jury back there, but we won't let you see them, so therefore, you know, the jury came back with guilty, and it's really just a clerk back there filling out a form. So yes, you have to have somebody supervising that. But there's also a problem because I've seen this in a federal criminal case, income tax case. The lawyer for the defendant, who was a friend of mine, made an excellent presentation that the jury convicted anyway, and I made a few inquiries and get back the word that several members of the jury received hints that if they didn't convict, they would be audited. So, in a case like that, the IRS should not know who the jurors are. But you're not going to get a just decision if the jurors are afraid of prosecutors or the agencies they represent. So, there are a variety of reasons why this is a good idea now, and it wouldn't have been necessarily 100 years ago. But, now judges are threatened with audits. We have several indications of that from judicial clerks that their bosses feel intimidated. Okay. Now we get into an area, one of my favorite areas. In mixed cases of law and fact, which includes all criminal cases, to suspend decisions on issues of law until all arguments are concluded. That means that with all the motions that get filed, all the issues of law that get raised, no decisions by the judge until all arguments are finished, and then do not impede the right of either party to make the arguments on the issue of law to the jury. The judge can require people to file their motions in advance of impaneling the jury, but not to make all their arguments before impaneling the jury. Because the jury has to be able to review the decisions of the judge. If it's going to bring back a general verdict of guilty or not guilty, it can't very well do that without the information about what the issues of law were and how the judge decided them. If the judge could conscientiously rule the way that he does because he feels he's bound to do so by stare decisis, by precedent. Says, well, I don't like this, I think it's unconstitutional, but the higher court ruled this, so I'm bound to decide this way. Well, the jury needs to be able to look at that decision and says, well, the judge might feel he's bound by precedent to decide it that way, but we're not. The Constitution says this, that's clearly in conflict with that precedent. We're going to go with the Constitution. And we took an oath to uphold the Constitution, and they were required to hand us a copy of it. Okay, and I have a copy of the Constitution here, and I don't see any authority in here anywhere for the statute under which the guy is charged. No authority. Can't, and maybe there is a chain of reasoning that leads back to a provision of the Constitution, but I didn't hear it. Nobody made that argument. So I have a reasonable doubt that the case has been proven. So, not guilty. Of course, it is important to realize how we got into this situation, is that judges are mainly former prosecutors. So they have a prosecution bias. They're members of the same tribe. They're not really neutral arbiters. And that's another reason why juries are needed. That was true even of the, back in England in the 17th century, 18th century. Now, I would also require that the jury gets copies of the pleadings, law books, except for one subject. If there's a motion to eliminate where the arguments cannot be made without disclosing the evidence that is properly excluded. But in a criminal case, no motions in limine should be granted to prosecutors, only to defendants. They're the only ones who can have a proper right to exclude evidence. You should not have a situation like the Davidian trial where essentially the defense had all this evidence of official misconduct on the part of the federal agents, and the judge wouldn't allow any of it. Now, of course, the form of the objection was, objection, Your Honor, irrelevant. Well, it wouldn't have made a difference whether it was a motion in limine or just objection irrelevant. The point is that they should not have been excluded from introducing that evidence. Okay. Another thing we need to do, we need to extend the right of the jury to other kinds of cases than we do now. There are whole large categories of cases for which there is no right to a jury trial. Now, originally, these arose from cases in equity courts. Originally, there were two kinds of courts, common law and equity. And we have merged them in this country since the Constitution was adopted, but we still have a legacy of that ancient English law. Okay? There's presently no right to a jury in a contempt of court. There should be.
Absolutely.
Both federal and state. On sanctions by the judge says, well, that's a frivolous argument. I'm, finding you $50,000. You're not allowed to file any more cases in any of the courts of this state until you pay the $50,000, and make the check payable to the opposing party. Now, first of all, if there's to be a fine, it should be payable to the Treasury, public Treasury, not to the opposing party. However, there used to be an action what's called abusive process before you lost, or before the case was decided, and malicious prosecution after the case was decided if you won. These were counterclaims that could be used if the opposition was doing things like making frivolous arguments or such. But you had to plead it. You had to make a case, and it would be decided on its merits. And what a lot of judges are now doing is they're bypassing all of that and says, I'm on their side on this one. You're out of here. You pay $50,000 to them. And they haven't had to file anything but a general denial. Well, in my view, that doesn't work.
How does that conform to the letter of the law?
The law is vague on this and other subjects. Most of this comes under the heading of judicial policy and practice, which is why it could be addressed with legislation. But you have to word it properly. For example, one of the things you have to do is to say, pass a bill that says, it shall be a reversible error for the judge to do such and such, or to fail to do something, such and such. That makes it very, very definite that he is going to be overturned on appeal if he does that or doesn't do that. As long as you leave it vague, they're going to do their own thing. So one of the reasons why we have this huge body of law that we do is to deal with abuses of discretion that have occurred. Generally law starts out kind of vague, and you leave it to the discretion of judges and other officials to apply it to particular cases. And over a period of time, dissatisfaction with the way that discretion is exercised leads to more rules, more refinements, more detail, and eventually you've got the kinds of things that you had with ancient Hebrew law, where every little detail was had a rule for it. Other societies have had similar problems. Well, we have that problem too. If you can't get good, wise people to serve as judges and other officials, then you're going to be overrun with laws and rules and so forth to deal with the ways they will otherwise tend to abuse their discretion. So we have to attack the problem on several different fronts, and sometimes the only way you're going to get decent people in there is to, you know, adopt more rules that leave them with less discretion. Okay, family court. Now this is a tough one because the family courts are overloaded as it is with all these divorces and parental abuse cases and all that. The simple fact is that too many of these decisions are being made by riding roughshod over due process. And you're not going to get justice unless you can get the jury in the picture. Probate court. Texas is famous for corrupt probate courts. An executor can do just about anything. In particular, he can steal the estate. I've seen many cases of that because there's no supervision by an outside body, like a jury. Bankruptcy court. Believe it or not, there are such things as state bankruptcy courts too, but federal is the main one that we usually think about. And we see a very cozy relationship between the bankruptcy judge and the pool of guys he appoints as receivers in the various cases come before him. And again, there needs to be jury intervention in that process. Permanent injunctions. Well, interestingly enough, in Texas, there is a right to a jury in a permanent injunction. Texas is almost unique in that respect. So that's one of the reforms that was already been made. And we can commend our fellow Texans for having done that. But that doesn't mean that judges can't do it anyway and leave you wondering, you know, saying, but Judge, I'm entitled to a jury trial. And it says, okay, we'll schedule it, a jury trial 10 years. In the meantime, this temporary injunction applies to you. Temporary restraining order, strictly speaking. So, competency hearings. You know, the way things stand now, if you've got a lot of money and somebody thinks that you're not managing it wisely, they can just come in and say, oh, you're crazy. We'll lock you up and take all your estate and we'll do what we want with it. I've seen cases of that. Famous way of abusing. You know, a lot of the parties involved might have been a little odd, but they weren't really crazy. You know, any disablement of a right to keep and bear arms, for example, should be decided by jury. And writs of habeas corpus, quo warranto, and so forth. Judges have proven they are not willing or able to handle those properly. And we need to be able to have juries decide those cases as well. Legal education. Well, first of all, it should not just be the American Bar Association that certifies law schools. It's okay to have certification of law schools, but they should be certified by all kinds of investigative bodies, including grand juries. The legal profession should be split. Having one legal profession is really a bad idea. Now, in Britain, they have the difference between barristers and solicitors. They typically work together, but they actually play different roles. That's a good start. But what I advocate is splitting the profession into advocacy, compliance, teaching, and support. And compliance and teaching tracks would be for judges. Ordinary trial lawyers would go into advocacy, and support would be for the paralegals. They should each have their own professional career tracks. Now, what doesn't forbid anyone from training in more than one, but there should be much more of a division among the members of the profession, so that you don't get a crony system, as you do now. They form a tribe that protects themselves. There should be multiple qualifying exams by multiple examining bodies. And there should be legal writing requirements. Every lawyer should have to publish a law review article. We should repeal all state bar acts. The Texas Bar Act is due to sunset in 2010 unless renewed. So we got only another year to build up support for allowing it to die. And I'm encouraging people to organize to do that. It is current practice to discriminate against those who are sued for malpractice. They're the litigants and their lawyers. It's usually impossible to get a lawyer in a jurisdiction to take a case for malpractice against another lawyer because, as he will explain, he'll never win another case again in the courts of that county. That is one of the first forms of abuse that I encountered, and it's a serious one. Now, in California, I discovered it's not so bad. The state is more dispersed socially. The counties are much larger, and it's easier to sue another lawyer for malpractice and not have your legal career ruined. But I'll make it a crime to discriminate against those who sue lawyers for malpractice. You know, make it a cause of action, but do something. And you create a jurisdiction for grand juries to hear complaints against lawyers, to issue presentments of their findings, and even authorize criminal prosecutions. Lawyers enjoy a privileged position in society. They should be subject to supervision by grand juries. Under judicial rules, no deference to legislation or administrators. Right now, the tendency of judges is to presume that any act passed by Congress is constitutional. That's not the way the Constitution is supposed to have it work. The burden of proof is always supposed to be on something being authorized. And if you can't prove it's authorized, the default decision should be that it's not authorized. And the judges have been trying to turn it around, not just for acts of Congress, but for acts of regulative agents, IRS agents, or SEC regulators, or whoever. Well, what those guys do is they might gather evidence, they might be credible, but they should still be required to prove what their findings are. They shouldn't just be rubber stamped by the court. There should be no binding stare decisis. It's all right to treat previous cases as persuasive, but a minority opinion in a case could be just as persuasive, if not more so, than the majority opinion. Just because 5 judges on the Supreme Court agreed and 4 disagreed doesn't mean that the 4 are wrong and the 5 are right. And anyone should be able to cite the minority opinion and saying, or majority, or whichever opinion he likes, and saying, I take a position, or I agree with the opinion by that judge in that case. And it shouldn't matter if it's in the majority or minority. as you will see in the email that I sent to the group, that long list of all the ways they try to avoid deciding constitutional issues, they should be required to take it as a duty to resolve all issues that come before them, and to make a good faith effort to do that. Now, it might only be in dicta, in commentary, but they should address it. Make a good faith effort to try to do so. Now, a lot of them will argue, well, we don't have time to do that. And that which gets back to my original proposal, that if you have many, many more judges doing judicial duties on a part-time basis, then they can devote more time to do it right, including going through every one of the issues raised by any of the parties or even by interveners or the amicus filers or whoever. And, let's just make this a law review article. Here are all the issues you guys have presented, and I'll sort them out here, and this is my opinion, and you may or may not agree with it. It's not binding. It's only, persuasive, maybe, hopefully. But at least I'm addressing it. I'm not just letting it fester. And again, a unanimous decision by a multi-judge panel to sustain the power of government over a challenge by an individual. Now, under judicial rules, further, there should be no requirement of a jury to take an oath to follow the laws given by the judge. They should follow the instructions concerning procedure, but as to what the law is, well, the judge can convey his opinion on the law if he wants to, but it shouldn't be considered an instruction. And if he should convey his decisions on questions of law. If a motion has been made, he decided it, they should have the benefit of that decision and the arguments made on both sides of that decision. If the jury has questions about the law, they should be answered by expert witnesses. The judge is not necessarily an expert witness. The lawyers are not necessarily expert witnesses. Let them bring in somebody out from outside, somebody who can really give them a true expert testimony, subject to cross-examination and rebuttal. And if that still doesn't satisfy them, then they probably should decide against the plaintiff or the prosecutor, because there's too much doubt involved at that point. And juries should be allowed to call their own witnesses on issues of law. They shouldn't rely on the judge or the lawyers or the parties to decide who the experts are. Each of these guys are lining up people to support his position, but hey, let's try to go out here to the university and see if we can't find somebody who's uninvolved and who can give us a neutral point of view on the subject. Now finally we get into the forms of pleading. We need to revive the writs of quo warranto, habeas corpus, procedendo, prohibito, mandamus, and certiorari. These are the 6 major prerogative writs. Originally, when the Constitution was being ratified, New York demanded a series of amendments, and they ratified the Constitution on the understanding that their amendments would be seriously considered. And one of them was that any citizen should be able to bring a writ, where they meant one of these writs, in the name of the people. Originally they were issued in the name of the Crown, but now that the United States was separated from England, the people became the Crown, as it were. So in the name of the people. And the problem is, like with the writ of habeas corpus, most judges don't know how to handle a writ of habeas corpus. They try to treat it as though it were as a motion to show cause. with a burden of proof on the petitioner. That's not the way habeas or quo warranto or whatever is supposed to work. The writ is, the petition is the writ. It's a summons. After it's filed and served on the respondent, it's a summons to him to respond to it. The order is not the writ. The order is the decision by the judge whether or not the official has proven his authority. But that's not the writ, that's the order. And most judges today, they don't know that. Amazing. They don't teach it in law school. So we need to teach them. And to the point, we need to also establish that the relief sought by such writs issues by default if no hearing is conducted. The judge just can't file it away and try to forget about it, and nothing happens. We also need to revive the right of demur. Demur is another one of those ancient common law forms where you can challenge the jurisdiction of the court or the law before you have to plead, guilty or not guilty. Today, in a criminal case, one is put in the position of having to plead guilty or not guilty to a charge that may be unconstitutional. And to plead not guilty is to kind of accept that it's constitutional, when in fact you don't believe it is constitutional. And it should be possible to argue that point before you have to enter a plea. What the courts do now, they just say, well, we'll just enter a plea of not guilty, and we'll settle it later. Well, that doesn't really work, for several reasons, and we need to get back to the way things used to work on that point. So that concludes my talk for this evening. Hope you found it enlightening. I haven't gone into as much detail as I would like concerning actual bills before the U.S. Congress and before the state legislature. But what I'll be working on during the next month is exactly that, and I'll be posting it to, uploading them as files or sending them out as email to the members of this group, and of course to other people as well. So be on the lookout for those emails, and you may have some ideas of your own that you might want to bring to the group. You can push the button.